Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1039 et al. Michigan Electric Transmission Company LLC petitioner versus Federal Energy Regulatory Commission. Mr. Street for the petitioner, Mr. Kennedy for the respondent, Ms. Roby for the interveners for the respondent.
Good morning, Mr. Street.
Good morning, Your Honor. May it please the court. The commission unlawfully deprived Metsy of its exclusive ownership of network upgrades because it interpreted the term system to mean the same thing as facility in the transmission owners agreement, when both plain English and the relevant context would give distinct meaning to those terms. I'll turn first briefly to standing, which we think is straightforward. FERC rejected Metsy's claim of 100% ownership and denied Metsy's request to delete the interveners from the generator interconnection agreement. A decision from this court enforcing the plain language of the TOA would redress that error by giving Metsy 100% ownership. FERC's order had immediate injurious consequences. Rather than being able to enforce a contract with enter into a contract with just MISO and Eagle Creek, the generator, knowing that it would have 100% ownership of the network upgrades, Metsy instead was required to negotiate and ultimately enter into a contract with MPPA and Wolverine, parties that it did not wish to contract with and which it believes do not have any rights.
Is the kind of formal label for what you did was a protest? Am I right?
Yes.
So when you file a protest, do you get to ask for sort of the equivalent of declaratory relief? Is that normal?
Yes. Yes. The parties propose what they think the GIA should look like. MISO, as the RTO, accepts one proposal and puts that forward to FERC. Because my client Metsy objected, it was an unexecuted generator interconnection agreement. It goes then before FERC, Metsy files its protest saying, here's what we think the ownership allocation should be with respect to these network upgrades.
And then FERC would have had the authority to say, we agree, and this proposal by Michigan Electric is the proposal we order everyone to do.
Yes. Yes, because the transmission owners agreement provides scenarios with respect to who owns these network upgrades. So it was up to the commission to properly interpret that plain language and declare the proper ownership of those network upgrades. And we would, of course, had 100% under our plain reading of the TOA.
This doesn't bear on standing, but it's relevant, I think, to where we are, which is to say, now there's another unexecuted agreement, correct? I mean, it has not resolved. It's been accepted for filing, but it has not resolved the question of ownership.
Yes, Your Honor.
Does the commission have the authority to determine ownership under those circumstances, whereas you've already been remanded and negotiated and still can't reach an agreement? Or is it possible there'll just never be an agreement and the facilities won't be built?
So because the new GIA has been executed and accepted by FERC for filing, even though nobody knows who owns what, the facilities are being designed and built by Metsy. But the question remains as to who owns those facilities. So there is no guidance to the parties from the commission with respect to how to negotiate this or who owns what. And there's no suggestion that the commission is going to pull a rabbit out of a hat and find some provision that resolves this dispute. So we are sort of in limbo, and that goes to part of our standing that we're having to go forward and design and build these upgrades, not knowing whether we even own 100% or 33% or 0%.
Was there a requirement that you go forward with construction?
No, the generator wanted to get this power onto the grid. And so we were forced with the idea of either just not executing an agreement at all and just letting things sit, which is an injury in itself because we can't begin collecting the return, or going ahead and executing with the ownership blanks left open for resolution by this court. If there are no further questions on standing,
If the court were to hold this is not right, when do you assume FERC would respond to resolve the question?
as I mentioned to Judge Ginsburg, I don't think FERC is ever going to be able to resolve this question. They sent it back to the parties to be negotiated. So I guess at some point the parties would just put their heads together and come up with something and propose that to FERC. Our point regarding ripeness is that there's already an injury now because we've had to negotiate, spend dollars and cents and time negotiating. We've had to effectively enter into this contract or just sit there and delay. And those are currently dollars and cents injuries of the type this court recognized as sufficient in the Rio Grande and Great Lakes cases. There's also the planning and the financial uncertainty that comes from not knowing what upgrades we own. But I'll stop there on standing unless there are further questions. Turning to the merits of the transmission owners agreement, Section 6, Romanet 1, gives Metsy 100% ownership because the network upgrades here connect to a, quote, single owner's system. Metsy owns the system to which Eagle Creek will interconnect, while the interveners own a facility on that system. This is made clear in the order below. In paragraph 2 of the order below, FERC says, and I quote, "The Styx-Murphy line is jointly owned by Metsy, MPPA, and Wolverine, and is located on Metsy's transmission system in Michigan." At paragraph 7 of the same order, the commission says, quote, "Eagle Creek is planning to construct a solar generating facility which will connect to Metsy's transmission system." That should have been all the commission needed to do to resolve this case. It's even more striking if you look back to previous FERC orders involving these very same assets, the Michigan Public Power Agency order and the MISO order, which we discuss at length on pages 24 through 26 of our opening brief. The MPPA order, FERC said that MPPA and Wolverine have, quote, "joint ownership interests in transmission facilities that are part of the Metsy transmission system." MISO order referred to Wolverine's, MPPA, and Metsy's joint ownership of certain transmission facilities on the Metsy system. So FERC knew that these were distinct terms that had a meaning, and those orders reflect that the meaning of the term system is the legacy collection of interconnected transmission assets that Metsy inherited from the integrated monopoly, while the term facility means one component of that system, such as a transmission line or a substation.
To which FERC, as I understand it, says basically, look, we use those terms inconsistently in other sources to which you don't point, of course, and it really is not that clean cut. If it were that clean cut, there'd be certain anomalies. Let me take you to the one of most concern. It's at 43 in their brief. What if the interconnection takes place between facilities owned by A and B, but those facilities are within the footprint of C's system? Section 6.1 and 6.2 would be in direct conflict. What do you say?
Well, I think it's important to note that FERC does not make any textual arguments in support of its position. It does take pot shots at our position.
6.1, but it's saying, look, if you're right about 6.1, then 6.2 is deprived of all meaning, and all upgrades anywhere connected to the system would be would be owned by Metco.
So let me respond directly to that. First of all, I want to point out that that is a hypothetical conflict that FERC does not identify has ever arisen in a case, and there's a good reason for that. If there were this potential conflict were to ever arise between Romanet 1 and Romanet 2, either the commission or the court would construe those together to give both of them effect. And I think what the commission could do is to say, if the facility, if the new transmission connects between two facilities within the same system, then Romanet 2 is the more specific provision, and that would control. But I think this is also very important, that there's a reason that this is likely never going to arise. And Metsy actually explained this quite helpfully before the commission at JA 189 to 90. And there Metsy explained that FERC applies Romanet 2 when there is a long-range transmission facility that is connecting two different systems together. It's typically two different systems that are far apart. For example, a long-range transmission line between Iowa and Wisconsin. That's what Romanet 2 applies to. It doesn't apply to generator interconnection. It applies to these long-range. So under those...
Is there anything in the terms of 2 to limit it that way?
Right.
No, I don't think it's in the terms of 2, other than it does say it connects between two facilities, which suggests that this is
You
not
just
a...
gave me an example where it's 2 systems.
Well, it's two facilities on two systems. And that's just practically when that has applied, because if it is not a generator interconnecting to a system, which is Romanet 1.
I think the transcript will show that you just said, we could think of this as connecting 2 facilities on 2 different systems or connecting 2 different systems. In other words, you're using the terms interchangeably.
I'm not using the terms interchangeably, Your Honor. I am saying that where the times in which FERC has, as a practical matter, applied Romanet 2 is when there's a long-range transmission facility that happens to connect facilities on 2 different systems. And therefore, as a practical matter, the conflict is not going to arise. That's just the nature of what 2 is getting at, is long-range transmission facility.
Is that point in your brief, that precise point?
I don't think that that precise point is in our
I
brief,
don't think it is.
but we did point out that this is a hypothetical conflict that has never arisen, and that the court or the commission could reconcile the 2 conflicts.
Let me ask,
I think the way the brief puts it is basically, if that were to arise, they'll figure it out.
And I think that when we went back and looked at what we had said below, we explained very helpfully to FERC why this had never arisen. And FERC didn't contest that interpretation. In fact, I think it even...
Where is that?
It's at 189 to
You
190.
said that earlier. Okay.
Yes, and I don't have the direct site, but the commission recognized that argument in its order as well.
at one point in the brief, the commission says the ownership determinative distinction in section 6 is the number of miscontinent owners at the points of interconnection, not whether the point of interconnection is viewed as a system or facility. Moreover, as the Sticks-Murphy agreements themselves establish, the Sticks-Murphy line is a collection of components that work together as a system to transmit electricity. Why is that wrong?
Well, first of all, Your Honor, that is a post hoc rationalization. The commission never...
Wait, I mean, all of it, much of what we're getting from both sides is winging it because the language isn't clear anywhere, and you're both doing your best to try and give it some sense. And I'm respectful of both sides. So I don't know about post hoc rationalization. You just came up with something that wasn't in your brief either, and we listened. So if you just answer.
Sure, of course. I'm not the agency, but beyond that, so I mean, the commission could have written, or the transmission owners could have written the tariff that way to focus on points of interconnection, but it doesn't. Instead, it uses the distinct terms systems and facilities. And I think we can see the absurdity in what the commission is saying when we compare their initial order versus their rehearing order. Recall that in their initial order, they're addressing the intervener's argument that 6 Romanet 2 applies. And there they say Sticks-Murphy is, quote, a single facility at paragraph 88 of the rehearing order, of their initial order. In the rehearing order, they turn around and they say, no, Sticks-Murphy is actually a system. So there's no single system owner because everybody owns part of that system. So those two things cannot be held together, I think, in one's mind at the same time.
So the last one counts.
Well, it's certainly...
Seriously, I mean, it may be, both of you are kind of winging it along the way. The language is hardly clear in the contracts and anything else we're being directed to.
Well,
And system facility, quite frankly, those two terms are not clear cut in the materials we're looking at.
well, I would respectfully disagree without belaboring the point, which is that in this very order and in the previous orders that I quoted to the court says the Sticks-Murphy line is a facility that exists on Metsy's transmission system. So the system is this legacy set of interconnected transmission assets A facility is something like a line or a substation. The commission knows that. It uses those terms that way all the time. It doesn't use the terms interchangeably. That's an argument they came up with on the rehearing order to, for whatever reason.
Where have they ever said that definitively?
I think that they said that when they used the language that I quoted.
That's all you have, just this case? I mean, you're saying it like everyone in the world understands this. And so in preparing, I was looking for an expression of that world-known understanding. I don't see it anywhere.
Right. So system is not a defined term in the TOA. To that extent, you're precisely correct. So I think that it's appropriate to look at the way FERC uses that term, which again is to refer to this geographic system. Whereas a facility, just in plain English, a facility versus a facility is going to be something that makes up the system. So I think you're right. There's no definition that we can point to. We can point to the way the commission used the term in regard to these very assets, and we can point to plain English. We can also point to the fact that under the commission's interpretation, there is a gap in coverage of the transmission owners agreement. It gives no guidance to these parties as to who owns the network upgrades in this scenario. I think that's a strong strike against FERC's reading.
If you said a minute ago that a facility is a line, and I think your understanding of system is that a system is a bunch of connected lines. Why shouldn't we just view that as one long line?
Well, because it is more than lines, it's substations, it's all of the other assets that are.
Can a single facility, as you understand it, include like line, substation, line?
I don't think that would be one facility.
That would
no.
be a system.
Well, it would not be a system. It could potentially be multiple facilities. A system is the system as a whole, which is a geographically coterminous legacy set of wires that really got inherited from the monopoly. That's the way the commission uses it when it says the Metsy system.
Just zoom out for a second. Yeah. The Styx line, you say that's a facility, not a system.
Yes.
And I get that it's shorter than the rest of the system, but is there a substation in the middle of the
Yes.
Styx Murphy line?
Yes.
So why is that not a system with three facilities? Let's say there's only one substation. Line, substation, line. Why is the Styx Murphy line not a system with three facilities?
Well, okay, so you can have a system and you can have a multiple number of facilities that still are not a system. The system is the overall collection. Just as in our.
Now it just sounds like you're. I think I'm pretty sympathetic to your argument. So I'm just trying to figure out.
Well, let me
push it and test it a little bit. Sure. And sometimes it sounds like you're saying like of a facility, a system is just like bigger than a facility. Sometimes you're saying a facility is a small system and a system is a big system. I know that's not what you're saying, but I wanted to see why that's not what you're saying.
Sure. No, a system is the total collection of transmission assets that the legacy transmission provider operates. So we wholly own 98 to 99% of all the assets that are transmission assets in Lower Michigan. That's our system. That's the way the commission uses the term system. A facility is any smaller component of that. I mean, it could be one facility, it could be multiple facilities. But I think the direct answer to your question, FERC gives you, right, in its order at paragraph 88. It says the Styx Murphy line is a, quote, single facility. So it has told us.
I mean, but Judge Ginsburg says, sometimes they call it a system, sometimes they call it a facility.
Well, right.
I don't want to do like, a cocktail party and just pick out your friends.
Well, I think that the fact that they're calling it a facility at one place and then saying, oh, well, it could be a system over, on rehearing shows the irrationality of its order.
Is that the only time that they make the switch? Because that would, the timing there would seem artificial. I mean, that would support your argument.
That's the only, I mean, let's put it this way. The other side has not identified any other time when a facility has been called a system. Okay, the only thing they do is use defined terms like transmission system, and those use transmission system to mean the collective of all of the facilities. And they try to say, well, that means system equals facilities. Well, no, system equals the collection of facilities. Now, I think, as Judge Edwards referenced, there is this point of interconnection theory. As I've argued, I think that that is a pure policy argument. It's not a textual argument. And maybe it would make sense to have written the TOA that way, but it's simply not written that way. Whereas Metsy's interpretation gives each term its natural meaning, and it makes sense as a practical matter. I think that's important because FERC's argument sounds in policy. Ours actually makes more sense as a policy matter. If you look at Section 6, Romanet 1.
You're a bit over your time, Mr. Street. I know we've asked you a lot of questions and I'm partly responsible for that, but if you can wrap up in a minute or so.
Certainly. Thank you, Your Honor. This will be the last point, which is that our argument makes sense as a policy matter. If you look at Section 6, Romanet 1, you see that ownership of the network upgrades goes along with, quote, the responsibility to construct those network upgrades. It makes sense to keep the ownership and the responsibility to construct with the legacy system owner, because the legacy system owner is the one with the expertise and experience in building transmission infrastructure. And here that's Metsy. Under the commission's argument, you could have one-off facility owners like the interveners with ownership of network upgrades, even though Wolverine is a generation company. It doesn't have the expertise or the experience to construct those facilities, or as one goes on to say, maintain such facilities?
Who maintains and operates the Stick-Murphy line? Is it just you, only you?
Yes. So I think that...
And on your metaphor about the skeleton and the bones, so, bones are connected by things that are not bones, I think. It's been a while since I did, high school anatomy or something. But as I understand it, facilities are connected to each other by other facilities, right?
Sure.
So I think the analogy breaks down a little bit there.
I'm not sure that I follow, but I think I would say that even if there are facilities connected to other facilities by facilities, that doesn't make that small group a system in the sense that the commission uses the term system.
I'm just still a little confused about why. Sometimes it sounds like you're saying system is big, a facility is small.
Mhm.
If that's it, that doesn't seem like a very good line to draw between the two, because how do we know that the Sticks-Murphy line isn't big enough to be a system?
Besides what the commission said, that it's a single facility.
I think that's a strong point.
So I would put it this way, Your Honor. It's not that a system is big and facilities are small. It's that a system is the overall collective, and you have individual facilities that are part of that system, and you have more than one facilities that are also a subcomponent of that system, whether it's the Sticks-Murphy line or whatever the Sticks-Murphy line connects
Is
to.
the Sticks-Murphy line multiple facilities?
No, I think we would agree with the commission that it's a single facility.
But it does have lines connected by generator stations, right?
It has lines that are connected to substations. Yes. Yeah. And
each substation is a facility?
I don't have any quarrel with the commission saying the line is a facility. That's the way the Sticks-Murphy line is a single facility. That's what we've always argued. I think that makes sense. But even if you view it as two facilities, that doesn't make it a system.
Councilor, you referred us to 189 to 190 in the joint appendix. I thought it was for the proposition that the commission uses 6.2 when it's faced with your Iowa to Wisconsin example. But if a quick read here suggests to me this is not an empirical observation at 189 to 90 at all. It's your interpretive point.
I think that it is our view of what the commission, when the commission has used Section 6, Romanet 2 to assign ownership, because in those instances of the long range transmission connecting Iowa and Wisconsin, for example,
Right.
the commission gave equal ownership of that transmission line to the Iowa system and to the Wisconsin system. And again, the commission didn't push back on that and say, no, that's an incorrect interpretation. In fact, remember, it rejected the intervener's reading of 6 Romanet 2. So I guess I would wrap up just by saying, whatever the hypothetical issues that could arise with our interpretation, they pale in comparison to FERC's, which is conflating the key terms to mean the same thing and is leaving gaps in coverage that leave the parties to negotiate without any guidance.
Good morning. Thank you. Good morning, Your Honor. It's Robert Kennedy on behalf of the Commission. The Commission appropriately found in this case that Section 6 of the Transmission Owners Agreement doesn't have ownership of network upgrades turn on whether the point of interconnection is better characterized as a facility or a system. That conclusion is consistent with the structure of Section 6, which uses the terms interchangeably, as we discussed before, consistent with other portions of the tariff and the Transmission Owners Agreement, which equate facility to system, and it avoids some of the interpretive problems that are associated with Michigan Electric's interpretation. With respect to the structure of Section 6, I think you see the interchangeability of the terms most clearly in 6.2 and 6.3. They both describe precisely the same situation, a new piece of infrastructure being put onto the grid between two existing pieces of the grid. In 6.2, it's described as being placed between two facilities. In 6.3, it's described as being connected to systems. And I think that shows the key variable in Section 6 isn't whether the point of interconnection can be dubbed a facility or a system, but the key variable is where is the interconnection taking place? It uses the word connected, and who are the owners, the number and their identity. The terms facility and system are just simply used interchangeably, and that's consistent with the various definitional phrases that the Commission, definitional terms that the Commission went through in its analysis to determine there wasn't some ownership determinative distinction between facility and system. You see in paragraph 86 of the initial order and footnote 89 of the rehearing order, the Commission cites the tariffs generator interconnection procedures definition of transmission owners. And in there, it describes facilities as a portion of the transmission system. The definition of transmission system in those generator interconnection procedures describes the system as simply the facilities owned by the transmission owner. And these are the pro forma terms. The parties incorporated the same terms into their proposed interconnection agreement. And the Commission also looked at the definition of system in the transmission owners agreement. And all that says is that the facilities comprise the system. So nowhere in the way the parties used those terms is there a stark distinction between a facility and a system such that Section 6 should be read to have ownership turn on that.
Do you agree that Michigan Electric maintains and operates the Sticks-Murphy line?
That is my understanding. I believe the interveners pay some of the operational costs, but I believe there's an agreement that they'll be operational, and that was the same agreement that they proposed with respect to the upgrades.
Do you know of any other facility, there may be many, I don't know, but do you know of any other facility that is maintained and operated by someone other than the system owner?
Well, I mean, your question gets into what is a system. I will say in footnote 1 of the intervener's brief, they cite to MISO's website where MISO lists all the facilities that have been transferred to their operational control. And you can go through it, owner by owner and see in a number of those cases, there are jointly owned facilities. In particular among these three parties, there are, apart from the Sticks-Murphy line, there are a number of jointly owned facilities. I don't know, frankly, what the agreement is among all those parties as to who will operate. But it's not an uncommon situation that there is jointly owned facilities.
Someone could say, I don't operate this. I don't care whether, for the purpose of this question, let's not distinguish between a facility and a system. Right? I don't operate this thing, but it is mine.
I'm sorry, what?
I don't operate this system, but it's my system.
Well, I don't think that's an unreasonable, interpretation.
Has it ever been said?
I don't operate the system, but well, I mean, that's the position here of the parties. I don't know whether it's come up in that way, but it's certainly not unreasonable. I mean, you think,
But when things are unprecedented, it's a red flag. I'm not saying it means you lose.
well,
If this is the first case when anyone has ever said, I don't operate this system, but it is my system.
well, I
would
think
be-
this is this is the first case there had, at least as far as I've been able to see, where there's been a dispute under interpreting section 6.1 here. But again, I think to your point, Your Honor, it's important to look at section 6 doesn't just say system, it says single owner system. So, I mean, we're almost at opening day. George Steinbrenner was the owner, was a owner of the Yankees. There were minority partners, but he certainly operated the team. That didn't make him the single owner. So I think that's one of the, you saw it in the discussion today, one of the fundamental problems with Michigan Electric's position is, what is a system? They say a single line, even though it transmits energy over the Styx-Murphy line, 45 miles, that's not a system. All these definitions that the parties use just say it's the facilities turned over to MISO. So again, you go to the MISO website and you see Wolverine and Michigan Public Power have turned over a number of facilities to MISO, including the Styx-Murphy line. Is it on their system? Is it on their system? There's no language in the operative agreements here that would help with that determination. They sort of import some connectivity requirement almost. But if you look at, again, you go to that website, the parties have jointly claim ownership interest in 3 lines stemming from the Murphy substation.
There's, as you know, there's 3 or 4 times at least where FERC said it's Michigan Electric's system. Why did you say it's their system if it's not their system?
Well, I think the reason, again, the commission, until rehearing, this crystal clear provision that supposedly governs this wasn't raised to the commission on rehearing. So it was not asked to kind of take a hard look at section 6.1 and see did the parties mean a distinction between system and facility. I mean, we don't dispute that in the normal course there could be some distinction between a system and a facility. But the question before the commission was, did the parties intend in section 6 for ownership to turn on some undefined distinction between the two? And we think the commission reasonably found that they didn't. The other interpretive problem that you noted, Judge Ginsburg, is what happens if, again, there's multiple jointly owned facilities within, presumably, among these parties. So what happens if there's a network upgrade between 2 jointly owned facilities under section 6.2? The answer would be they split it, but taking their position that everything within our legacy facility is ours, they would get ownership under 6.1. And there's a conflict there. If you just look at where is it connecting.
And they also, at that point, defending that point, faulted the commission with the point that there is no evidence on the record that there are any other facilities part of the Metsy system that are not wholly owned by Metsy.
I believe their point was that there's not any facility on their system that they don't at least have some ownership interest in. There are a number, as I understand it, of jointly owned facilities. There's no, I think their statement was that there's no facility that they don't have any ownership in that falls within whatever however they define themselves. And that, to be fair, that was the circumstance the commission used in talking about the conflict that emerged, but it will equally emerge with a connection between jointly owned facilities.
Responsibility is it to resolve this?
I'm sorry?
Whose responsibility is it to resolve this?
Well, ultimately, I mean, this kind of gets into why we raised the standing argument here. The commission didn't make an ownership determination, didn't preclude single ownership, didn't require joint ownership. If you look at section 16 of the intervener's brief, they suggest that there could be additional provisions that bear on the ownership question here. But it did, I mean, the commission freely acknowledged that this case did reveal a gap in the tariff, and petitioners see that as a strike against the commission's interpretation. I would just point you to section 6 here. On the top right, it has the revision numbers. And when this case started, we're up to revision 36. These are complex systems with complex questions. So it's not uncommon that factual disputes show
show a gap in the tariff. I think.
Whose responsibility is it to?
So if there is no other provision that bears on it, I guess the parties would have to come to an agreement of shared ownership, propose that to the commission. If the commission viewed
Suppose they
that,
don't. Whose responsibility is?
well, then it could
Isn't
be,
it
it could be up,
ultimately
it could be up to Mid-Continent to say there is a gap on our tariff. Here's how we're going to revise it. And
That's the
and we're
final
gonna-
decision?
well, it would have to be proposed to the commission, and the commission would have to approve it as
So
being
it's
just
the
and reasonable.
commission's responsibility to decide.
Ultimately, yes, in response to, in reaction to what either these parties or MISO puts in front of the
So
commission.
you're saying MISO could revise and submit for approval a change in the transmission TOA?
It could say, yes, commission, you identified this gap. Here's how we're going to fill it. Of course, that raises the question, okay, well, does that apply to, how does that apply to this situation in terms of retroactivity? So I'm not saying that's I'm not saying that answer won't, that result won't resolve all disputes.
It's a new submission that's now before the commission. Was that submitted by MISO or by the other parties?
I believe MISO submits it on behalf of the other parties. And my understanding, they described it as a placeholder agreement, and they can describe it better than I, but as I understood it, they're saying, we entered into this agreement so the connection can go forward. We'll resolve ownership issues after this case is resolved. So they wanted to get something on record so it can go ahead, but left open the question of ownership.
That they will resolve it after this case is determined?
Well, yes.
They've already filed the document.
Right, but it doesn't lay out how the ownership of the network upgrades.
I understand that. I thought they were leaving it to the commission to do that.
Well, as I understood, they're saying we're going to leave this open until the court rules on this appeal, and then we'll take it under consideration and figure out a path forward.
I'm not sure whether you're answering it clearly or you're trying to avoid it.
No.
It's either it ends with the commission and they have to decide this question or not.
Ultimately, the commission will have to approve the generator interconnection agreement.
If they come back and say we can't reach a resolution, we still think we own all of it. Who's going to resolve that?
Then I think that might be a question for the commission to take evidence and resolve it itself.
And that's only might be in your mind. You think, but you're not.
Well, if this is a gap, then the commission would have to ultimately, if the parties are unable to come to a resolution, yes, then the commission would have to resolve that question somehow.
Okay.
Let me see if there are any other questions. No.
Thank you, Your Honors.
May it please the court, Deborah Roby on behalf of Intervenors, Michigan Public Power, and Wolverine. And I'd like to start with Judge Edwards' question first. The commission will decide this. The commission will decide this because what was put before them was a very specific provision, section 6.1, and started with section 6.2. Are we dealing with facilities between two owners? And the commission said, we can't find that. That's not here. We don't have that situation. Are we dealing with, it was only then, by the way, that Michigan Electric comes in and says, let's talk about section 6.1, because at the outset of the proceeding before FERC, they were the ones who said, Appendix B, section 6 doesn't apply at all. After the commission said section 6.2 doesn't apply, they come in on rehearing and say, let's look at section 6.1. So they're being critical of FERC for switching between facilities, which is what 6.2 addresses, and system, which what 6.1 addresses, is a result of the switch in position of Michigan Electric here. So what the commission has before it right now is a newly executed GIA, Generator Interconnection Agreement. All three of the TA transmission owners have signed that agreement, by the way. And there is a placeholder in that agreement that says the three transmission owners will have to discuss among themselves how we're going to resolve the question of ownership. And if we can't come to an agreement, which is why we're here premature, by the way, if we can't come to an agreement, it doesn't mean that we have no way to address it. It doesn't, Michigan Electric doesn't like what the commission's decision was on 6-1, but it's not here because of that decision. It cannot deny it is one of 3 owners. It is a joint owner along with Wolverine and Michigan Public Power. This is by agreement. We are strange bedfellows, but here we are. The 3 of us are going to have to work this out. And if we can't rely on 6-1, we have the MISO tariff. Attachment FF of the MISO tariff, which is not before the court today because it was not before the commission before it. We have other provisions in the tariff that we can look to help us resolve this. And if we can't resolve it on our own, then we'll have to put forth our best arguments to the commission yet again on how to address this. But this can be addressed and will be addressed before FERC. We are here prematurely. The next thing I'd like to address, if I could, is section 6.1 and the distinction between facilities and system. And the significance of the point of interconnection. Even Metsy agrees, you don't get to a system without going through a facility. The point of interconnection here is to the Styx-Murphy line. A point of interconnection is not an abstract concept. A system is not an abstract concept. You only get to the system by going through the facilities. So the facility at issue here is a Styx-Murphy line that has 3 owners. And under the MISO tariff, the owners agreed that when network upgrades are ordered by MISO, under the MISO rules, it is the owners that have the right to own those upgrades. That's how we get to ownership among the 3 of us. Judge Walker, you asked about, can a single facility be a system? The commission has answered this question as well. Footnote 90 of the order on rehearing recognizes that there are transmission owners who have a single facility, and that single facility can be a system and is a system. So the commission's use of facility versus system depends on the circumstances presented before it. And section 6 uses the terms system and facility in a lowercase term so that it can address the different circumstances that exist throughout the very vast region that is the Mid-Continent region.
What is the difference between a system and a facility?
Well,
Depends on the circumstances.
Well, and let me talk to let's use footnote 90 where there is a single owner that has a single facility that is in the MISO region that is also a system. And let's apply that in the context of section 6.1. If that line were part of the Metsy system, as Metsy says, but Metsy is not the owner of that line, then under Metsy's interpretation of 6.1, it would be Metsy that gets the right to own the upgrades to that line because it's part of its system. That's an absurd result. And it's no less absurd when you apply it to the facility that is the Styx-Murphy line, where it has 1% ownership versus 99%.
And that's not just a hypothetical, there's a real one.
That's a real world. There could be an interconnection to that line, to the owner that is listed in footnote.
Record, like,
yes.
What is the example of it?
I'm not sure I'm understanding the question exactly, although
you could say it's the Lansing Ann Arbor line. That's the example of it.
It's referenced in footnote 90, and I forget the name of the.
They do name it.
They name the company, yes, that owns that. Okay. It's their line, and it's a singles owner's line. In which case, if there's an upgrade to that, you're in section 6.1 territory. So is it a facility or is it a system? And the commission correctly looked to the governing documents, the transmission owners agreement. They looked to the MISO tariff, including the generator interconnection procedures, to help inform what does system mean in this case. They correctly and reasonably determined we can't apply section 6.1 here because we don't have a system that has a single owner. And again, Metsy agrees. And Metsy says a system is made up of facilities. So whether you look at the Styx-Murphy agreement or the Styx-Murphy line as a facility or a system, as a facility distinct from a system, as Metsy claims, or whether you look at the Styx-Murphy line as a system, as the commission reasonably concludes, the fact is you have a system made up facilities and 6.1 cannot apply.
Michigan Electric has, whether you want to call facilities or systems, that cover like 2/3 of Michigan. the Lower Peninsula, I think. Is that right?
Yeah, I'd like to touch on that. Michigan Electric is the majority owner. Reference to the Michigan Electric system is often a term as an ease of reference. If you want to think of it in terms of law firms, you have 6 partners and you're going to refer to maybe the first or 2, but it's an informality and there's no legal significance given to that. And other times, it's the legal significance attached to it is that means it's the facilities owned by Michigan Electric. So when somebody's using the Metsy system, they're using the facilities that Metsy owns.
Does anybody else operate any of the facilities on what I'm going to call the system covering 2/3 of the Lower Peninsula?
Yes, Wolverine is a transmission owner, and it operates its system. It has ownership in facilities that, along with Metsy, that Metsy operates, and that operation is by contract. But it makes it no less of a system that belongs to Wolverine, which means we're not in a single owner's system.
And the way Michigan Electric is thinking of it, that Wolverine system would have to be part of the Michigan Electric system. That's part of what Michigan Electric is calling its own system.
Well, I don't want to answer for that. I don't think so. But
It does sound like there's a Wolverine system and there's
a system can refer to and does refer to the facilities that you own, that somebody else may operate. It doesn't mean that it's not a system that's yours. And also to your question.
Some people operate, you're saying some people operate things on Michigan Electric's system, that some people other than Michigan Electric operate facilities on Michigan Electric's.
Michigan Electric operates facilities in the lower Michigan territory. There are other owners and systems in the lower Michigan area.
They're not part of Michigan Electric system.
Well, they are not part of the facilities that Michigan Electric operates and that Michigan Electric calls its system. And I guess my point is, it is not a system that has a single owner, because there are other owners of the facilities that make up the system. The fact that they operate it doesn't make it theirs any more than if somebody else were operating it. That operation is by agreement. And yes, there are other areas in MISO that have that same arrangement. We have clients that have the same arrangements.
Judge Edwards? No. Thank you very much.
Thank you.
Maybe three minutes for rebuttal.
Thank you, Your Honor. A few points in direct response there. First of all, I think it's important to note that the commission didn't just say Metsy had a system in an offhand way in its previous orders, and even in this order. It said that Metsy owned the system and MPPA and Wolverine owned a facility on that system. So they used them distinctly. Now, we've got talk about a Wolverine system. That would have been cited all over their brief if there was any reference in a previous commission order to a Wolverine system. There's a Wolverine facility that is on the Metsy system. I think your questions about operation go right to the point. We had the Steinbrenner hypothetical. The problem here is that we have plain text of Section 6, Romanet 1, which says that the ownership of the network upgrades goes along with the responsibility to construct and maintain those upgrades. Metsy is the one that actually is going to maintain and construct these upgrades, as we've already heard. And otherwise, we have generators that don't even know how to build transmission, much less operate transmission, that are owning network upgrades. So I think that goes strongly to the plain text. We've heard the argument about that it would be absurd if there was a facility in which we own 0%, but it was within our system. There is no evidence of that, and I can tell you that is not the case. There is no point on Metsy's system where we don't own at least some of a facility. In fact, we wholly own 98 to 99%.
But that's not in the record.
Well, that's not in the record either way, because the commission just used a hypothetical and it didn't say, and here's the point on the system. And of course, FERC hasn't pushed back on that. I think it effectively conceded that in its argument this morning. I think what we heard from Judge Edwards' questioning of the commission is that the gap that is created by the commission's interpretation is a huge practical problem. It throws the parties back into totally undirected negotiations with no idea who's going to resolve it. The commission suggests that this should be done through a revision to the tariff. Well, A, that presumes this is not unambiguous in our favor already, but I think that that cuts against them. That means if FERC does not like the way the plain language is being applied, or MISO doesn't like the way the plain language is being applied, then they go and revise it to put in the points of interconnection theory. You don't jam up the transmission owner, Metsy here, that has relied on the plain text of that agreement as part of the transmission owner's agreement. And finally, I would just point out, I think at the absolute best, FERC can get to ambiguity under a very lenient reading of Chevron step 1. And if you think that that is where we are, then the court does have to address whether Chevron-like deference continues to apply to interpretations of contracts and tariffs after Loper-Bright. We don't think it should hold that, but if you go with our interpretation that the plain language is unambiguous in giving Metsy 100% of these network upgrades, then the court does not need to reach that question.
Did you say something a minute or two ago that's responsive to the footnote 90 argument that Ms. Roby mentioned?
I have to say, I'm completely perplexed by that argument. I looked at footnote 90 in both the order and the rehearing. It does not discuss any point on the Metsy system or on any system where the system owner does not own some part of the facility.
Thank you.
Case number 24-7053. Metropolitan Municipality of Lima appellant versus Rutas de Lima S.A.C. Mr. Lane for the appellant, Mr. Healy for the appellee.
Good morning.
May it please the court. I'd like to focus on the public policy issue in hopes of bringing some clarity to the substantive and procedural framework for evaluating it. The district court committed a straightforward legal error. The court refused to even engage with Lima's bribery claim, reasoning that the claim was to be determined exclusively by the arbitrators because it focuses on the underlying contract rather than the arbitration award itself. That conclusion is foreclosed by Supreme Court and circuit precedent, including Enron Nigeria, which held that a court's, quote, analysis of the public policy issue extends to the underlying contract. But that error alone is enough to vacate and remand. But it raises the critical question of what happens next, given that the tribunals found that Lima had not proved the bribery and courts ordinarily defer to arbitrators' factual findings. Enron provides substantive guidance, and this court's decision in the Termo Rio case provides procedural guidance. Federal courts cannot turn a blind eye to evidence showing that the underlying contract was procured through bribery. As Enron declared, the question of whether enforcement of the award should be denied on public policy grounds is a question for the courts to answer. And that independent judgment acquires special force and scope where the underlying contract's origin is criminal.
Did
Enron
give dispositive weight to the arbitrator's factual findings?
I don't think it did. It said that the the findings would be due significant weight, but it would not doom the challenge if there were evidence to the contrary, that the claim in Enron ultimately failed because they didn't have the facts of the fraud. We have the facts. I think it's critical that Enron emphasizes the long-standing fundamental need of the federal courts to protect their own integrity by ensuring that they do not enforce a contract obtained through bribery or fraud, lest they be made party to the criminal act and allow a party to profit by its own fraud or crime. So that's why Enron sets up this idea of, we will give significant weight, but we're going to look at the evidence, and that has to include not only the evidence in the arbitral record, but also any new evidence, because as Enron also emphasized, and I'm quoting, courts may not elevate the parties' contractual choices above the fundamental need of courts to protect their own integrity. So ultimately, the courts have to make sure for themselves that they are not enforcing a contract that was procured through bribery.
I'm at page 290 of Enron, and it says ICC declined, ICC noted, ICC's determination, ICC credited, ICC found, ICC found, ICC found, ICC was unpersuaded. It just seems like maybe they're not completely deferring it 100% to the arbitrator, but boy, I mean, it seems like they're giving a ton of weight to the arbitrator's findings.
Well, to be sure, a court is going to start with what the arbitrator found, what the record was before the arbitrator, how the arbitrator reasoned through it. In Enron, the arbitrator...
Just to be clear, I wasn't quoting from the facts section. Like, this is the final analysis section of the thing.
I understand. And in Enron, the court is explaining that the analysis of the arbitrators was supported by the evidence, and there's no evidence to the contrary. The court says it to, I think it's, I don't have the page, but the court says at one point, the ICC's findings, to which an enforcing court owes substantial deference, doom Nigeria's public policy defense in the absence of evidence or equities warranting the piercing of Enron's corporate veil. It would have allowed a different result if the evidence supported a different result. But
Where in the opinion does it re-examine even a single factual finding?
well, I think that's what it's doing in the parts that you're reading. I think that's what it's actually doing, but it's saying, in effect, these are good findings. The evidence is there. The analysis is there. We don't see a problem with it. We don't have evidence to disagree with it. Whereas here, in our case, we have substantial evidence to the contrary. In fact, I would say overwhelming evidence that Rutas and its parent Odebrecht secured, expanded, and preserved the concession contract through bribery. Rutas doesn't deny that Odebrecht's bribe department made secret illegal payments to Vieron's campaigns while the base contract and the addendum were being negotiated. I'm sorry, Judge.
Both the arbitrators and the district court disagreed with that.
They did.
Well, I'm not sure I'm following your argument. What's impermissible about the arbitrators saying we don't see any evidence to support your claim of violation of public policy or bribery or whatever you're calling it? And the court says at great length, I've gone through all of those findings and they seem correct to me.
The district court here, I'm sorry, the district court did not do that.
The district court did do that.
No.
I just read the opinion again last night. The district court went through and said, the arbitrators found, and I don't disagree with it, the arbitrators found is those claims are not supported.
The district court said, when it addressed the public policy defense at JA 1241,
No, I
that it could
understand.
not.
I understand that the district court said that's a determination for the arbitrators. But the district court along the way has to satisfy herself that there's nothing here that would warrant her tossing this out. And the district court did, in fact, put the public policy question, however she stated. I don't know whether it's right or wrong. It doesn't matter. The point for me is the district court went through both panels the determinations and explain how one affected the other, in effect to say, I don't find support for the claim that is being made here with respect to a violation of public policy. She was saying that. I don't know how else you read her opinion to say. What do you think she was saying? She agreed? What was she saying? I don't know. I think there's a problem here, but I have to defer to their judgment.
Respectfully, Your
think?
Honor, I don't think she did that at
Do
all
you
in her
think
opinion.
that's what she did?
No, because I think that to the extent that she discussed the facts at all,
Yeah.
she did it in the context of the fraud claim. And
Yeah.
what she said was, she said there are problems. She perceived problems with the evidence as a matter of, for example, hearsay or incomplete transcripts in that nature. She said, I am not going to, she called it a ramshackle record, which I think is an overstated criticism. But she said, I'm not going to allow evidentiary proceedings to try to address the evidentiary concerns because I can't do that given that I am not allowed to review an arbitrator's determination as to bribery. The court never actually assessed, even on the arbitrator's own records, whether they were sound decisions. I mean, the second tribunal, for example, it makes certain criticisms, like it doesn't believe there was any motive to bribe to get the contract after the contract had been awarded.
Right.
It doesn't believe there was a motive to get the addendum because it was contemplated by the original proposal. But the evidence before the tribunal,
You think the district court was struggling with those findings?
I don't think the district court actually considered those
Oh, wow.
findings. I don't think that's in the opinion.
You must have read two different things. The district court went through all of it and said no, and then said no, took it all the way through and said, I'm not seeing it.
The district court addressed it's a long opinion, addresses a lot of different claims. When it comes to the findings of bribery, all it says is I have concerns about the evidence and I can't conduct proceedings to address those concerns because this is exclusively for the arbitrators. It's half a page and that's the totality of the analysis. And I think that even if the court is going to limit itself to the arbitral's record, it has to actually examine whether the arbitrator's findings are actually supported by the record. And we don't think that's true for the reasons we stated in our brief. I would like to turn very quickly to our final argument that the second tribunal erred in excluding the annex. And I would just like to emphasize that I think the key question is whether Lima actually requested that the annex be included. The best evidence to see that it did is the tribunal's own order, which says that it refused to open a new stage for the production of documents, plural, which certainly goes beyond the indictment. And it authorized Lima to submit only certain parts of the indictment, quote, without additional annexes. And Rutas's final opposition to the request similarly said that Lima's request, quote, implicates submitting the complete prosecutorial file with all its annexes. I really don't think there's a basis to say that that Lima hadn't made the request for the annex.
It's a little odd that your evidence that Lima requested more does not include anything Lima said.
Right.
Well, Lima, I mean, we
Which
go over
the
this in the
district court
briefs,
said.
but Lima says it wants to submit all the documents that it's received from the
District
prosecutor.
court didn't buy that.
No, but this is a paper record. I mean,
I'm wondering what you're reading. The district court, that's an example of something. The district court specifically went through that and said, no, that's not the way it played out. Lima's wrong.
and we disagree with the district court
That's a
because,
different question.
well, the
You're
evidence
suggesting
here
that the district court didn't do anything. The
on that
district court-
issue, no, I agree. The district court did address that issue. I'm saying as to the facts about bribery, the district court did not address that. On this issue, the district court did, but the record is right there in the documents, and I think the district court got it wrong.
What's your best quote of something Lima said at the second arbitration that shows it requested to submit the annex rather than just the indictment?
If you'll give me 1 second. Well, I don't have the citations, but they're in our brief, but Lima multiple times used the word documents in its request. In its request for reconsideration of the denial, it spoke of introducing new evidence. Instead, it had obtained the documents it wishes to incorporate. That's a 349 to 50 in the JA. It's talking about the documents it received from the prosecutor. It didn't fully explain what all these documents
It
were.
comes down to using the plural, is that it?
In Lima's papers, it uses the plural in the context of talking about the material, the package of materials that it received from the prosecutors. I think you get more explication that includes the annex from Rutas's opposition and the tribunal's order. Lima's paper submissions don't actually use the word annex, I don't believe.
And what was accepted?
Only the indictment, or what we call the information, a portion of it was allowed to be submitted, but not the
I
underlying
understand that, but you're
evidence.
saying one document,
Part of one document.
part of one document.
Yes.
Said a portion, but I mean portions.
Portions relating to a specific topic were allowed to be introduced. But then the problem is that the tribunal then said, well, we can't believe that because we don't have the underlying evidence to corroborate. And this is just the prosecutor's allegations. We need the documents, we need the transcripts that they're relying on. That's what was in the annex that the tribunal had excluded.
Did the indictment contain the key excerpts from the annex?
The indictment, yes, I mean, it either quoted or reproduced evidence in the annex, which the tribunal reviewed, but said we can't rely on this because just as a court could not take the prosecutor's word for it, we have to see the evidence.
But I thought that the annex would have still been just more of the prosecutor's word. In other words, if the problem with the 500 pages of excerpts from the indictment is that the 500 pages were one-sided, I'm not sure you solve that problem by submitting even more pages that are one-sided.
Well, I don't think the tribunal said the problem is it's one-sided. I think the tribunal was saying the problem is it's just a characterization by the prosecutor. If we had the documents.
They were quite specific about a number of problems though, right? That they were elaborating on being just a characterization, that they were not sworn, that they were not subject to cross-examination, 2 or 3 other observations like that. It was an informal, essentially, document, not a court approved document.
I think those are actually more the district court's concerns. The tribunal.
I thought it was parroting the.
Well, there's a little bit of a difference. The tribunal focuses on the fact that the witness statements were not what's called corroborated. So they're sort of proffers of, there's sort of a statement, and it's a formal process in Peru. As cooperating witnesses, they make a statement. They get benefits as a defendant if their statement is corroborated by the prosecutors. And at the time of the arbitration, those statements hadn't been corroborated by the prosecutors, but they did actually corroborate each other, and there actually were papered documents that corroborated the testimony. So if you step outside that formalistic process in Peru and look at the actual evidence, there was corroboration. That corroboration was in the annex, and that's what the tribunal excluded. That's why it's a problem, but it would have actually addressed the tribunal's concerns about the lack of corroboration in the documents. I don't think the tribunal raised.
The tribunal itself would have had to make its determination based on the annex.
Yes.
That the allegations were corroborated.
Yes, which it was basically saying it was going to do. It was saying we have to make these evaluations, factual evaluations for ourselves. We need the evidence to do that. MML tried to give the evidence. It rejected the evidence, and then it said, well, we can't.
And the next tribunal says, okay, we've seen the evidence. It didn't affect anything.
They never looked. The tribunal never actually looked at the evidence. They never saw the annex. They only had the indictment.
Okay, so none of this was available to the first tribunal. That's
correct.
You're right about that, yeah.
It didn't come up until
This was
late in the
second
second
tribunal, that's
process, right? After the close of the discovery in the second tribunal.
Thank you. I'll give you a few minutes on rebuttal.
Thank you.
Good morning. David Hilly for Rutas de Lima. May it please the court. Let me pick up where we left off, if I may, with respect to the annex. First, there is no question that the annex was never requested to be submitted by Lima. Lima's request is set forth at JA 347 through 352. There's not a mention of an annex, an exhibit, supplement, nothing. They refer to the prosecutorial indictment only. They're the ones that had it. Nobody else had it.
I mean, you just heard Mr. Wayne say they asked for documents, plural, and, you know, I can kind of see how you might think of the indictment as one document. So it seems like, you know, his argument is they had to have been asking for more than the indictment, or else the S wouldn't have been on the word document.
But the arbitrators didn't know there was an annex. Whether they used the word, a plural word, documents, I mean, if you look at their request, it says prosecutorial indictment numerous times throughout it. That's what they asked for. They never used the word annex. So when the arbitrators said, you can submit whatever pages you want, just don't give us any extra annexes or writing, I submit that's because the arbitrators hadn't yet concluded whether they were going to allow the 10-page supplemental brief that they later said that they could do also. It had nothing to do with the annexes to the index. To the indictment. They didn't know there was an annex to the indictment. They could not have been referring to that. And let's also not forget the context in which this arose. This is 7 months after the hearing on the merits had been completed. The arbitrators deliberating, preparing their award, and Lima comes in and says, hey, there's a press report about an indictment, and we want to put that into the record. The arbitrators who had control over the process of the hearing, what evidence comes in and when, under the UNSA trial rules, could have said, no, it's too late. But they didn't, and said, give us the index, whatever pages you want. They chose 500 pages. And to go to your question, Judge Walker, they absolutely had excerpts of the testimony, presumably the best ones, that the prosecutor selected in the indictment itself. So there's just and the district court reviewed this thoroughly and concluded that the extra information in the excerpts doesn't change anything. Let me go back.
Just so you're on the record on the public policy, I understand what the other side is arguing, but I think the district court statement is somewhat confusing here because there's an overlap between vacating on public policy grounds and vacating on statutory grounds. They're not distinct. In other words, some of the statutory grounds can be seen to subsume public policy grounds. You disagree with that?
By the statutory grounds, you're referring to the FAA and the convention.
Yeah.
Well, the convention has the express reference to public policy, so for sure it's included there, Your Honor.
And otherwise? In other words, I don't see them as, it's an interesting legal argument we've developed since the Supreme Court made its observation about you stick with the statutory grounds and that's it. But there are public policy grounds that are being stated in the name of statutory grounds here as I read the district court's decision. I'm just curious to see if you want to weigh in on it. And that's why I read what she said, but then I read all the findings that she is endorsing. And to me, I don't know how that can become an error, whatever you may think the Supreme Court meant to say, because to the extent that the nature of the corruption and alleged bribery, et cetera, alleged corruption, alleged bribery, are there to be considered. She considered it, and those are public policy type questions, right?
I think I'm following you, Your Honor. Look, there were claims under the FAA, there were claims under the New York Convention.
Right.
There's a dispute or an open question as to whether under the FAA, public policy non-expressly stated in the provisions of the FAA, whether it's still a valid basis for vacatur. We submit that it's not and that it shouldn't be. We should be limited to the statutory things. But there's no question that the court and we have to deal with public policy anyway, because it is a basis for non-confirmation under the New York Convention. So she dealt with it, I think, the district court dealt with it, recognizing that it had to deal with it one way or another. And I think dealt with it extremely thoroughly. And so on the public policy issue, Your Honor, so I want to be very clear here. The deference given to arbitrators in the context of public policy, when what the arbitrators actually considered evidence on and ruled on is extreme, if not absolutely complete. Judge Walker, I was focused on the same exact page of the Enron decision as you highlighted, 290, which showed all the ways in which they deferred to the ICC arbitration. And on page 291, this court said the question before the enforcing court is limited, quote, the district court had no choice. And that's really true. That's the way arbitration works in the context of public policy. When the arbitrators have been seized with the question of here whether corruption exists or whatever the public policy may be, and they make the decision, that is what the courts rely on. They don't go behind it. In fact, the U.S. Supreme Court, in the United Paperworkers case, where the Fifth Circuit had declined to confirm an award, it was an employee at a paper manufacturing facility who had been caught smoking marijuana on the grounds. The arbitrator said, well, I don't think he should have been fired because it wasn't clear. The Fifth Circuit said, no, that's against the public policy of operating dangerous equipment while under the influence of drugs. The U.S. Supreme Court said, the parties did not bargain for the facts to be found by a court, but by an arbitrator chosen by them who had more opportunity to observe Cooper, that was the employee, and to be familiar with the plant and its problems. Nor does the fact that it is inquiring into a possible violation of public policy excuse a court for doing the arbitrator's task. And here, there's no question that the arbitrators considered all the evidence and gave a detailed analysis. In the first arbitration award, over 20 pages are dedicated to the corruption question. That's JA 445 to 465. In the second award, 63 pages. That's JA 141 to 204. And both tribunals came to the same conclusion, that there was no connection between any payments that may have been made and the concession contract here. And that was, they spelled out their logic, the difficulties with the timing that made no sense. When these alleged payments were made, the contract had already been awarded. Why would somebody pay for a contract, a project that had already been awarded? And for the subsequent contracts like the bankability addendum and the memorandums of agreement, those documents simply carried forward what was already in the concession contract. There was no new benefits that came with those. So again, why would anybody make payments to get something they were already entitled to?
Everything that was allegedly within the compass of violating public policy presented by the other side was considered by the arbitration panels. And the district court confirmed, even though the district court said, I'm not going to decide public policy. The district court was confirming the findings of the arbitration panels, right?
That's absolutely right, Your Honor.
That's why I think there's confusion as to how she wrote it. I understand the claim being made, but it seemed to me on this record, everything within the compass of public policy, arguably, was considered and resolved.
It was, Your Honor. And in the proceedings below, Lima was much more focused on a fraud-based argument. The public policy argument was not the sharp focus as it is on this appeal. Now, the judge, of course, dealt with all of it, but she discussed what the arbitrators had found in the context of the fraud claim, which they are now no longer pursuing in this court.
Did the district court re-examine the arbitrator's factual findings about the underlying contract?
I believe that the court examined all of those findings and observed and, to my reading, agreed with the problems of the logic of Lima's claim, the timing of when these payments were made, the fact that no new benefits were given subsequently, something that they weren't already entitled to under the project. So yes, I believe that the district court did review those conclusions, certainly stated no disagreement with them. And my reading of the decision is that she agreed with them.
Now, the other side, I have it straight in my head. The other side is not, because this becomes crucial in this case. The other side is not disputing the timing. In other words, the arbitrator's statement of, well, this occurred on this date that couldn't have been fraud when something occurred well after that. That happened several times, right?
That's right, Your Honor.
The other side is not disputing the conclusion they may not like, but the district court said, yeah, look, this is what the findings were. They're not disputed. Those timing sequences are not disputed. And she was essentially agreeing you can't really have a serious claim of corruption or fraud if those timing sequences are right. And I think they're right.
That's right, Your Honor. Now, they try to emphasize to a greater degree on this appeal alleged payments that were made in 2010. And that was to Lourdes Flores, who was a candidate for mayor. Now, she wasn't the mayor. She was a candidate. And she didn't win the election. She lost it. And the suggestion is that somehow a payment to a mayoral candidate in 2010 had some impact on the municipal council in 2012 in approving, but the arbitrators said, look, that's just, they assessed this as well. And they just said, look, there's no way for us to link that. There's never been any investigation of anybody on the municipal council. This just doesn't make sense. So the timing didn't work throughout for the arbitrators. The district court reviewed it, didn't express any disagreement with that analysis. And what Lima is doing is asking this court to give it yet another do-over. And they're just not entitled to that under the law of enforcing arbitration awards in the United States and the strong public policy in favor of finality and enforcement of foreign arbitration awards. I can touch very quickly on the document request issue if the court would like me to.
Good. Do you have any more questions? No. Do you have any more questions, Jim? No, I think we're good.
Thank you. Thank you.
Maybe we'll do 3 minutes, please.
A few brief points. First, to Judge Edwards. I reviewed the opinion while I was sitting there. I would refer you to pages 1230 to 34 of the JA. This is where the judge addresses the fraud claim. And in that context, she talks about a mulligan or the new evidence, what the findings were on the bribery claim. And she also addresses the public policy defense. There is not a word in which she says that the findings were well supported. She makes 2 points. One, I cannot consider public policy defense because it's exclusively for the arbitrators. 2, I cannot consider the new evidence because I have evidentiary concerns about it. And I can't address those concerns because, again, this is exclusively for the arbitrators.
You said she didn't say a single word that the findings were well supported. Did Enron say a single word that the findings were well supported?
Right.
But Enron went through the process of assessing it and found that they were well supported. She didn't even do that.
Where did Enron say the findings are well supported?
I think the passages that you were quoting me earlier are what's doing that. That's how, the only way to understand that, I think, in light of the other language in Enron, that we give so significant weight to the findings unless there's evidence, or sorry, in the absence of contrary evidence. We have an independent.
Usually when we're reviewing findings from another court or, tribunal, an agency, we would say, the agency found X and it's supported, that finding is supported because. But Enron seems to just say the tribunal found X, period. Then it says the tribunal found something else, period. On and on and on.
I think that's because it was a clear-cut case. And the only way to square that framing of the discussion with everything that preceded it, as Enron set up the analysis, the need to preserve your integrity, you can't elevate the party's contractual choices above that need, and so on. The only way to square that is to say the court was looking at that record and saying, this looks pretty good. We really don't have any reason to disagree with this. United Paper Workers, which the other side just quoted, yes, it says we don't do fact-finding in public policy cases, but that did not involve the kind of problem that Enron is talking about, where the underlying contract is criminal. That creates the fundamental need to investigate, to ensure the integrity of the courts. That was not implicated in United Paper Workers. The final point I want to make briefly is about this timing issue. Timing doesn't matter for bribery. You can pay before, you can pay after, it doesn't matter. And here, the evidence is pretty strong that even though the payments came after the contract was awarded, the agreement for the quid pro quo came before the contract was negotiated and signed, before the financing was agreed to, before the addendum was negotiated and signed. We have testimony from participants in both sides, Castro for MML and I think Barada for Odebrecht, saying that Odebrecht was afraid it would lose the contract, afraid it might not be signed, afraid it might be terminated. The city had termination rights in the contract. There was a real risk, and they needed to lock it down. They needed to lock down MML support for financing, and they wanted to extend the benefits. That's what the addendum does, which Castro says explicitly was done in exchange for contributions to Villarán's campaign. So I think
This is
the
all in the annex.
a lot of it's in the annex, but actually the second tribunal acknowledged all of these points. It just didn't want to credit them because it didn't have the underlying evidence to back it up. Thank you.
Thank you.